Thank you. Hi, everyone. So, we're here today to talk about probate and, importantly, how to avoid probate. My name is Amber Zeuner. I'm one of the associate attorneys here at the Miller Elder Law Firm. And joined with me today is Courtney Brown. She's one of our paralegals who is a master at working these cases and is here to help join me in a conversation on some tips and tricks and common questions we get asked and things that are not true regarding probate. Courtney, if you want to just give a quick intro and say what you do so they have an idea of where we're going today.
Sure. My name is Courtney Brown, as Miss Sooner said. I'm a trust and estates paralegal, and I've been in the field of trust and estates for about 22 years now. So of course, over that time, the laws have changed and federal tax code has changed, but the intent of the families and the um, emotions they are going through during the process never change. So I hope we can give you some good information today that will help you decide your personal estate planning goals.
Yeah, and Courtney's a wealth of information, so I'm happy to have her here today so we can impart some of that to you guys and maybe get some answers to your questions on what, certain myths there are out there on probate and what's true. Before we go ahead and get started, I went ahead and mentioned this before, but so everyone knows, we will be recording these webinars as usual. So you'll get the link for the recording of this video after today's webinar concludes, but they are also available on our YouTube social media channel. So if you know someone who wasn't able to join us today and wanted to, or just someone who would benefit from it, certainly direct them to one of those sources so they can take a look and see if they can gain some knowledge that way. So let's go ahead and jump in then. We've got a couple different topics we want to run through, but getting to the main point of myths and tips for probate and how to avoid probate, importantly. So often I want to start here, Courtney. What is probate? So most people think of probate as a administration for their loved one's estate after they've died, which is exactly what it is. It's a court process that your loved ones would go through in order to get your assets transferred over to your beneficiaries. But it's very particular. Not everything goes through probate, and there are certain rules around probate that a lot of people want to not be involved with. We try to avoid probate as much as possible. So, one of the most common misconceptions I often get when talking with people about their estate plan is wanting to avoid probate and having a will, a last will and testament. So, most people are surprised if they've never had to go through the process before to know that a last will and testament does have to go through probate. It does not avoid probate. And actually, that's part of the process is when a will gets admitted to the court in order to get that process started and get those assets transferred. Part of that is approving the will and admitting it to probate. So that's often a common conversation we have is having a will does not avoid probate, but that doesn't mean we can't take other strategies into consideration with a will-based plan. There's a place for all of it. But then there are also other strategies that don't involve having to go through probate, which we'll touch on as we get through some of these initial conversations on what it is and what goes through probate. So the process itself, just to outline a little bit before we get into what goes to probate, is a court process that can be rather lengthy. And it is a process that is public to the general public. So someone could go to the court and it's not private per se. So a lot of people do want to maintain some privacy in their estate plan, and that's why we want to avoid probate normally. What goes through probate though? Because there are some things that don't go through probate. There are plans to keep assets out of probate, but what are we talking about when we say a probate asset? And that's where I wanna get Courtney in here on this one because she sees a lot of that and can kind of go through just a couple items of what we often see in a probate.
Sure, Amber, thank you. So what assets are considered probatable or what would trigger the need for a probate? So those assets would include financial accounts that are titled solely in the name of the decedent. That could include bank accounts, checking, savings, money market accounts, or other investment accounts. It can also include CDs, stocks, bonds, and also it can include beneficiary designated assets such as life insurance policies or IRAs or other retirement accounts that just do not list a beneficiary or where the beneficiary that was listed has predeceased the decedent.
Yeah.
Also included are assets that are titled or classified as real property. Any real property that the decedent owns solely in the decedent's individual name or as tenants in common with other people where their individual share is considered their individual share and it's not shared with the others, a tenants in common interest. So that could be a partial interest in a property.
Yeah, and I want to jump in here just to elaborate on that for a moment because that's a good point. When we have an asset we're thinking about going to probate, I hear a lot of what you're saying is it's when it's owned solely by the person themselves,
Yes.
which is a really big distinction. And what we're th talking about at that point is with property in particular, you can own an asset, but you can also have things with your spouse, perhaps, if you're joint owners, where some of those other types of designations actually will keep assets from probate. So, I think you went through a long list. There's quite a bit of financial accounts that can go through probate if we don't take some strategy into consideration on how to avoid probate. But also real property too. It's not limited. If you have an asset that's just in your name, it can go through probate. And that's where a lot of our strategies come into play to help make sure that if we can, we have the best plan, comprehensive estate plan in place for your needs, be it avoiding probate, or just making sure it's a smooth transition for your loved ones and beneficiaries outside of probate. So, I want to touch base real fast because a common question we often get too is our homestead, and how that have to go to probate.
That's correct, yes. So your homestead property is technically exempt from the calculations of the assets of probate. However, unless the property is titled with a spouse or with another individual or held in another vehicle that would keep it from going through probate, the homestead exemption of the property is only passed through a process that involves the filing of a petition with the court and obtaining an order. So yes, technically the homestead is not probatable, but you still need to have court interaction to pass that property on to whoever your heirs or the individuals named in your last will and testament.
Yeah, and I think the a good way that I often try to explain that is that the court's role really coming in on on this type of asset is just to say what is happening for that homestead. So a good way to it's really important to have a conversation because there are those other vehicles we talked about to avoid probate, and not just for your financials, but also perhaps for a homestead or other real property. Um, okay. And I did want to just mention for anyone who has a question that they want to ask, go ahead and you can pop that in the chat. And as we go through, I'll try and pull those for our conversation, or we'll circle back at the end. So feel free to pop those in the chat when you get them. Okay, so no beneficiaries, solely in our loved one's name after they passed away. That's really what we're looking for, it sounds like, when we're going through deciding if we need to open a probate with the court. There are some considerations for the process that I alluded to a little earlier that people don't want to probate because of. One of those is that it's accessible to a public. So it is an open process where you do file pleadings with the court in order to get this estate and the assets in it transferred to the right people. So it's open to the public, and that's not what everyone wants. We sometimes want more confidentiality and what was in our assets, what we owned when we died. Another big concern, though, is it's costly. Probate processes do take time. They can go up to a year to complete, depending on the circumstances of the estate. If it's simple, it could go faster, but they can take up to a year or even longer if there's more complicating factors involved, such as a higher tax limit. We have to take that into consideration, or a couple other types of assets that would require more involvement. Like, for instance, we talked a lot about property, but property outside the state of Florida is another big one. It's one of those red flags we kind of look for when we're doing an estate plan because that has to go through its own process as far as getting transferred. So it actually requires two probates then at times, one in your state where you passed away, and then one in the state where the land is located, the real estate. So that's another big reason a lot of people we want to try to avoid probate. Also, there is the delay. As we said, the probate process does take time. It's not something that happens overnight. You have to petition the court in order to get appointed to represent the estate if you're the person doing so. And the whole process before you can even make a distribution can take up to, give or take 4 to 6 months. So your beneficiaries are having to wait through that process in order to receive, what you would wanted them to get. And that's for a couple different reasons, the timelines for the court, but also what we call a publication process. That takes 3 months, and it is a way that we are required by the court to notify of an estate that's been opened to allow creditors or interested parties to come forth and show their interest in that they want to have notice of what's happening or file a claim. So it's a longer process. It's not going to happen overnight. And for that reason, along with confidentiality purposes and the costs for hiring an attorney and having to start that process with the court, it can be costly. Um, okay. So reasons we don't want to go through probate, what may go through probate. It's a little more involved. There's steps in the middle there for a probate process, including doing an inventory, doing an accounting, actually distributing the assets. So it's quite involved, which we don't always want. There's a lot of court oversight, especially if we have a really simple estate. So I see there's some questions. Let me just see what we have here. Okay. We've got one question. Can you include commentary about the value and positive attributes of probate? So there are some reasons we may want to go through probate. There are certain circumstances where we have a situation where we're receiving assets that we want to go to perhaps a special needs child. So we're forcing a probate in that instance because we don't want to do a trust. There's also other circumstances where we have really a simple probate or a simple estate. It's not very complicated. We don't need a trust for any other reason. You might do a small probate just for a homestead that wasn't able to have a certain type of deed put on it or another vehicle used. Um, there's a couple different reasons that can come about. Oftentimes, they're very particular to the person I'm on the phone with, though, or who we're talking to. It's going to be very specified for what we're looking to accomplish and their goals.
And Ms. Sooner, if I can jump in here,
Yeah, of
I would
course.
also say that one of the benefits of doing a probate or a positive tribute, if you have an intestate estate where the decedent died without a will, it allows the assets of the decedent to be distributed in one manner that is detailed by Florida law, and it's a fair distribution. And if the decedent had a last will and testament, it sees that the wishes of the decedent laid out in the last will and testament regarding distributions are completed. So I think that's probably the most important attribute of a probate administration.
Yeah. And I think it can come into play too on the circumstances with the family. If we're thinking that it may be contested or if it's really simple and everyone's on board, that can make a big difference in the plan and what we're looking to accomplish. So good addition. I see a couple of chats here that the chat was disabled, so I think we got that working up because I see more. But one more other question here. I have a trust. How often should I review my trust? So, good question. When it comes to our estate plan, and not even just a trust, but any plan that you have, a will-based plan or a trust-based plan, it's really important to review those documents on a regular basis. And then especially when there's a major life event. So generally you can take a look every 3, 5 years, 2 to 5 years, just make sure that the right people are who you intended to be included in your will or trust or other documents if you have a power of attorney, healthcare surrogate, living will. But also just to make sure that it's up to date too. There are changes. I think Courtney alluded to that earlier. Sometimes that happens, and we always want to make sure that there's not going to be any concerns about what your wishes are. Um, I see some chats coming through saying it's still disabled, but I do for the chat box, but I'm seeing the chat saying it's disabled. If our moderator could just double check that and let me know if we're having trouble. Okay. Just to finish up the thought while we get that sorted in case there's an issue, major life events really are a good point too to look at. If you have a death in the family or a new birth in the family, if you have a child, if you're married, if you're getting divorced, um, and a variety of different types of events that can happen in your life if it's altering some situation with your assets. Okay. So, good question here. The next one I see, I'm going to get into in just a moment. We're going to talk about that as we go through the conversation about avoiding probate, but beneficiary designations. Good question. We will get to that in just a moment because that is a really important strategy to actually avoid probate. So, couple of different items I want to talk about though, real fast for concerns with probate. We mentioned property outside of Florida. That's a big issue. We really, if we can avoid it, we try not to have those go through probate because it can be a difficult process if there's, multiple probates necessary. Safety deposit boxes actually require a court order to get into. So it's also a problem when we have a lot of a safety deposit box that we can't enter without a court order. So that's another consideration on where you're keeping your documents. And then we also have those loved ones with special needs that we mentioned previously, very briefly. If we have someone with special needs, there's a lot of special considerations we want to bring into the conversation in order to put the best plan in place because oftentimes going through probate can be very problematic for those family situations and dynamics. Okay, so I want to get into the main point now, I think, Courtney. We're here at the conversation to avoid probate. That's why we're here today. So, going off of, I want to get to that question here, beneficiary designations. One really important way to avoid probate is by having a beneficiary designation. Setting up your PODs, pay on deaths, setting up your TODs, transfers on deaths. Those are so important for different types of strategies that we're trying to accomplish if we're using a will-based plan and we're still trying to avoid probate because that will actually supersede it. It goes over your will. So those will go outside of probate in that way. And that's often a conversation we have on what that looks like when we're doing a will-based plan. Um, Courtney, I know you mentioned this one before a moment ago, but when it comes to properties, doing certain types of deeds, we oftentimes have families who want to do what we call an enhanced life estate deed, which sets up, if you will, a situation similar to a pay on death. You own the property until you die. There's a little more details there involved, but upon your death, we're naming the person that you want to receive that property. And it's a smoother transition than going through probate. However, there are some requirements and qualifications there. Mortgages can cause a concern if we have one still on the property, so it's definitely important to have a conversation with your attorney, financial advisor, to see if that's a good vehicle for you to use on your property because it's not for everyone. Okay, Courtney, I know we do a lot of trusts, and Courtney is our trust guru. So, just a quick breakdown, because a lot of the times I'll get a question on, I want a trust to avoid probate. But Courtney, a lot of what we do too is trust administrations. And I think
I,
it's important to highlight that.
yes, that's correct. So a trust will allow you to avoid probate, but number one, you have to make sure your assets are retitled into the name of your trust or that your trust is designated as a beneficiary for some assets. We don't recommend that for all assets. We do offer that service as part of our estate planning to help you fund your assets, but that is one way that you can avoid probate, making sure that you have a trust and it's properly funded. However, a trust does often, most times, require a trust administration to make sure that the assets of the trust that are held in trust get to where they need to go after you pass away. So while you are living, the assets held in trust generally are for your benefit. Upon your death, your trust becomes what we call irrevocable, and it is to benefit your surviving spouse or your descendants. And there are many rules, and it could be held in trust for those individuals, or it can just be paid outright. But it usually requires a trust administration process to do that. So it's a good way to avoid probate, but there are some, I don't want to say cons, but you just need to be aware that there might be additional work after you pass away.
Yeah, and I think that that's an important point to make for our conversation today because I always have a lot of conversations where people are wanting a trust-based plan to specifically avoid probate, but it always comes up with the conversation that you may be able to avoid probate, and there are many pros with that. There's more confidentiality, opposite of probate. It's a family administration normally. There's more creativity with a trust if we have certain wishes and desires that we can't do with a will-based plan that we could do with a trust. And in situations where you have property out of state, a trust-based plan can make it that one uniform process. So we don't have to do multiple different probates if we put everything in a trust. Caveat, you don't normally there's a conversation on what you want to put into your trust because you can do different things with different assets. But you can avoid having to do multiple probates with having a trust-based plan. But the conversation always ends up with there is a trust administration. It's not just done and done because you have a trust. So I always think that's an important point to make as determining which is best, a will-based plan or a trust-based plan. Because avoiding probate, there's many different strategies. It's not a one size fits all. I do see a comment here, just to reiterate. So POD is a pay on death and TOD is a transfer on death. Doing basically the same thing. Some accounts name them differently, but it's naming your beneficiary on that account for after you've passed away. So that it doesn't, and then that does not go through probate. Um, okay. Let me go ahead and just see what else we have here. Okay, so we have one more here. If you only have one beneficiary, doesn't the will just work instead of having a trust? So it's going to come down to what your estate plan conversation is and what the best strategy is. If you have one beneficiary, a will-based plan may be the best. You may not need a trust-based plan, but it's really going to come down to a much broader conversation, what your assets are, what your wishes are, who's involved, if we have different requirements for our beneficiaries. It's a much broader conversation, but there's purposes for both. It's not a one size fits all, like I said. You can have a will-based plan which covers all of your needs and avoids probate with these other strategies. Or you could have a trust-based plan if that's good for your specific needs. Okay.
And Ms. Sooner, I will answer the question regarding how vehicles can be registered or tagged. There really is only one way for a vehicle to avoid probate in Florida, and that is if you leave a surviving spouse upon your death. You never want to, we generally recommend not titling vehicles in more than one name. They should be titled in the name of the individual that drives them the most for liability reasons. You don't want to open up the assets of a second individual to liability. And we never recommend titling vehicles in the name of your trust. And that's for the same reason, for liability. So the best way, we've run into this quite a bit. If you have a surviving spouse, any DMV registered assets can simply be transferred to the spouse by a process at the DMV, where they would go to the DMV to do that. If you have children upon your death, the vehicles will have to be probated. Usually the goal is to not have vehicles in your name before you pass away. If you are no longer driving, or if you are in an accident or have an unexpected death, then those vehicles would have to be probated to be transferred to children.
And I think just to expand on that a little bit too, DMVs are pretty good to work with at times, but there are different needs for each person. If we have a vehicle that can be transferred to a spouse, that's great, but it's going to be an individualized conversation with your team of advisors, your estate planning attorney, your financial advisor, accountant, whoever you wish to be involved in the conversation on what works best. Oftentimes, some spouses do have their vehicles titled with an or other types of different strategies, but there is the concern on putting it in a trust that is often brought up, but it's going to come down again to your specific plan in place. Okay, let me go ahead. I see a couple more here, and I want to make sure I address these questions too. So, good question. When someone dies, who to call first? Attorney, financial advisor, accountant, who to see? I think you want to talk with all of them. Who you call first is going to be a a judgment call, I want to say, based on what we're looking at, but having an attorney in place, having your financial advisor in place, and an accountant in place, and having those contacts for your loved one easily accessible is really important for them to know who to contact and where they can look for this information. Your financial advisor can be a wealth of information, an accountant as well, and they can point you in the right direction for what assets may or may not have to go through probate because they may have those different types of designations on those accounts. But talking with all of them, having a conversation with a attorney versed in probate or estate planning, preferably, is important too to cover all of those bases. But your financial advisor, I think oftentimes, I think most people generally go there first. Okay, let's see. Yes, and that's an important point as well. So there can be some serious complications with reliance on PODs, TODs, and beneficiary designations on various financial instruments provided by financial institutions. So I can think of an instance recently, actually. And this is where I say, every plan is different. Every strategy in place is going to be unique to your situation. We had a probate recently where we had a beneficiary designation on an account, and that beneficiary had unfortunately passed away prior to our person who we were administering the estate for. That financial institution had a preset plan for what would happen with that asset if the beneficiary was no longer with us or if there was no beneficiary named, which was different than the will. So, when you are setting up those accounts, it's really important to look and make sure that what you're setting up for your POD or TOD or beneficiary designation, those documents match your wishes entirely. Because if something were to happen to your beneficiary, we want to make sure that that's updated constantly if something were to change. But then also, if there are provisions saying what would happen after if there is no beneficiary, because that could conflict with your intended plan. So it's really important to read those documents thoroughly. Okay. Does this include adult children or minors? Is this That can go to a couple different points. So I apologize. I'm not sure exactly which question you're asking that in relation to. But when it comes to this might have been in relation to the vehicles, I think, Courtney, for adult children or minors. Um, for vehicles, again, you can have spouses on them. The vehicles will work pretty well. Sometimes you can also work with a will. With minors, it's going to get complicated. That you really want to make sure you speak with your estate planning attorney and financial advisor because minors, if we're talking about inheriting assets, they could have to require guardianship if it goes over a certain amount. But they may not, if there's limited, it's just really going to depend on what we're really looking at comprehensively in the estate. But if you have a minor, we definitely want to make sure to look into these different professionals to have a conversation and make sure that they're protected because guardianships are our last resort. That's never the goal. They are costly, they're time consuming, and they will be in that guardianship until they reach 18. So if you have minors, it's really important to make sure that they're brought up in your conversation when you're considering what to do with your estate. Okay. Couple other tidbits here. I know we're getting towards the end of our time, but avoiding probate, I want to wrap up a couple different topic points here just to round it out. So, mentioning all of your professionals. We have quite a few sometimes between our attorney, accountant, financial advisor, people who are involved. What oftentimes happens is if our personal representative, that's the person we name in our will to administer our estate, or our trustee, the person we name in our trust to take care of our trust. If they don't know where to look for the information, it's kind of like grabbing here and grabbing there. You have to search through records, see what was out there, and it can be it can take time in a search. So often what is really helpful that we find is keeping a list, an asset list to delegate to say, what you have and where to find the contact information if you have these people in your life um, that can help your loved ones make sure the estate is wrapped up smoothly. Also, making sure that your personal representative and helpers know where to find this information. So again, safety deposit boxes, just to wrap this up, those require a court order. So I know we have a lot of people, they want to go to their safety deposit box because that's where they keep a lot of their important information, but they do require a court order to open if there's not another person owning the account, which is problematic in its own right. In either event, having a safety box, lock box that's at home, fireproof, waterproof, or a place that's safe where you keep your documents that they can be safe, making sure that your personal representative person managing your estate knows where to find that information so they can contact your financial advisor, attorney, or accountant and further and locate those assets. Oftentimes, if we have to do a probate and an asset is unknown, we could end up having to reopen that probate a number of years down the line because it became known that this extra asset was out there. And that's also more time and energy for your loved ones. So having a succinct location where everything can be found is really important to make sure this is avoided.
Ms. Zeuner, we have a question regarding passwords. So I just want to take a stab at answering this.
Yeah.
Password access after someone dies would only be granted to a personal representative. So that would trigger the need for a probate if you were trying to access assets that are password protected. However, you can make a provision in your trust that allows your trustee the authority to access these assets. So in order to avoid probate or to handle administering assets with passwords without probate, you would definitely need a trust in that instance.
And I think just to expand on that, because that's a good point, Courtney, a lot of us have accounts with passwords now. That's the go-to. Everything's online. But passwords are so important because we don't want those getting into the wrong hands. And we don't want people having those passwords that shouldn't have them. And while, having a trust-based plan may be a way to help put that role into someone we trust's hands in order to manage a trust. I would just I would suggest and caution that they are confidential passwords. We don't necessarily want to just be giving someone our passwords. And a way around that, and this gets into another point I wanted to mention, is a comprehensive estate plan. This isn't so much about avoiding probate at this for this particular one, but generally, a question I get often is my power of attorney's use after I pass away. And a power of attorney is not valid anymore after you die. It's a lifetime document. So that means, though, even if it's not valid after you die, that if you have a comprehensive power of attorney, they don't need your passwords. They can use that document with the authorities that you've specifically given them in order to take care of what you may need for them to help you with without giving them ownership or access more than you're ready to do. But that said, it is important to have this conversation again on a comprehensive basis and see what's best for you. I do see another question here that is very important and he's brought up a couple of these, so thank you. But financial intermediaries. So I'm going to just simplify this a little bit, but engaging with web-based estate planning, which means, different tools online to create your own will or create your own power of attorney. Sometimes people will seek these documents out because they're directed to one or multiple of these sources, but they are problematic in their own right. It's really important that you have a conversation with someone who understands these processes in depth in order to make sure that the document that you're signing is really what you're intending and what you need. There can be a lot of legalese in some of these online forms that could be confusing, but they could be very simple. They might not cover everything that would be important to have in a plan. They could be the bare bones basics, and that can actually cause quite a bit of damage at times after all is said and done. So, web-based plans, when I see them, I always do throw some caution out just because you're not getting that advice in that conversation to make sure that what is in that document is not just cookie cutter language and that it is important for what your needs are. Um, okay. So another question about passwords I see here. This is related to, yeah, I think Courtney just sent a message on this, but passwords, again, those are confidential. You would need a probate in order to access those. Now, you can put provisions in a will just like you could a trust, but once the probate is opened, that your person that you've designated can help access those through that process. But again, I think I want to circle back to why we're here today, which is avoiding probate. We don't want to go through probate because it has all of these issues that we're talking about with different timelines and just complex interplays. So making sure, again, just to go over that you have a conversation related to avoiding probate and making sure that it's a comprehensive plan. Just going back to those online forums, they can be not the best form for your needs if you don't have someone actually taking a look to let you know what's included and what's not and make sure that it does represent your wishes. But generally speaking, there's a couple different vehicles we can use. You can still avoid probate with a will-based plan. There's other strategies you need, though. Will does not avoid probate. Trust-based plans are wonderful, They cover a lot of different concerns of our clients and people out there who may be considering one, but they also have to go through their own form of administration. So I think at the end of the day, avoiding probate is usually what most people want to do, unless there's a reason. Going back to a comment we had earlier that you wouldn't want to, there is some value in forcing a probate at times. But having that conversation, reviewing your documents, making sure they're up to date, and taking these other strategies into consideration with all of your advisors, your financial advisor, your accountant, your attorney, and making sure that your plan is foolproof. Um, and I think to end our conversation here today, I want to just mention again, reviewing your documents very often for life changes and different changes in your wishes is important. And also reviewing them with an attorney as well to make sure that they're up to date, because that will allow your team, not just your attorney, but you're also talking with your financial advisor to make sure that nothing is falling through the cracks. And if you have a plan to avoid probate. Okay. I think we answered all of our questions here today. And that would conclude our webinar on how to avoid probate. If we have any other questions that people want to throw into the chat box, we do have just a couple minutes, but I'm not seeing any so far. Okay. Okay. Well, it was wonderful chatting with everyone here today just to go over some of these common misconceptions with probate that we have and how to avoid it. And we look forward to seeing you on our next webinar coming up. I believe we have one more coming up this month, but you will get our notices as well for that. And again, this will be recorded to go out for anyone who wants to review once more and see if they have additional questions. I hope this helped answer some of those common misconceptions. Thank you for joining me, Courtney, today. I
Thank
know we took some of
you.
your afternoon out of your time to do this, but it's been wonderful.
Yes.
Okay, I think we're all set. Thank you, everyone. Have a good day.